The three questions approach to legal proceedings, a jurisdictional inquiry framework. I. The nature of law and legal interpretation. The etymology of the word law is said to originate from the term law, itself derived from symbolic hieroglyphs meaning two legs walking. This allegory reflects law as a concept that evolves continuously. In modern legal systems, especially in the United States, over 150,000 new laws are introduced annually across federal, state, and municipal levels. By 1984, over 200,000 new laws had been enacted. Legal professionals often rely on research tools such as Westlaw, LexisNexis, and others to verify the current state of the law on any given day. 2. The court is a commercial forum. The courtroom, when viewed through a commercial lens, can be understood as a venue where agreements are initiated and resolved. As such, all courts are deemed courts of record. A judge's authority is strictly confined to the record, documents that formally present and substantiate a case. In legal theory, failure to respond to a contractual overture may result in a presumption of agreement. This includes tacit dishonor through silence. Accordingly, when attempting to establish a record of agreement, obtaining the identity of all parties involved is essential. 3. Purpose and strategy of the three questions framework. This approach, often associated with the redemption theory, reframes the courtroom experience as a deposition conducted by the defendant. It seeks to clarify the identity and authority of any claimants, while resisting jurisdictional assumptions through deliberate inquiry. Central to this method is the legal maxim, "He who asserts must prove." Upon appearing in court under duress, the participant should seek to clarify whether there is any substantiated claim against them. In effect, this shifts the burden of proof to the accuser and challenges presumptions of jurisdiction. 4. Procedural engagement, steps in the three questions protocol. Begin by requesting the judge's name. "I am here concerning that matter. May I have your name, please?" If a title is provided instead of a name, request clarification and a spelling of their full legal name. If the judge provides only a title, assert, your offer of communication is accepted for value and your dishonor is returned. Please state your name, not your title. Question whether the judge's professional identity is registered with the Secretary of State. Should the judge not provide a verifiable identity, proceed to 5. Request, "Do you have a claim against me?" 6. If the judge declines to respond, follow with, "Do you know anyone who has a claim against me?" Responses, or lack thereof, are treated as tacit admissions. If a prosecutor alleges that the state holds a claim, request direct evidence of such claim, such as a certified assessment. V. Challenging assumptions and asserting rights. Continue with directed requests to the judge to have the prosecutor confirm additional charges. Verify possession of the assessment for said charges. Produce audit trails and financial records tied to the claim. Disclose the bar card registration number of the prosecutor. Confirm whether the court has subject matter jurisdiction. These strategic inquiries are designed to compel transparency and reveal procedural deficiencies or lack of legal standing. VI. Assessments, appearance bonds, and discharge mechanisms. Appearance bonds may be requested to assert agency over one's legal identity. If denied, this creates an opportunity to present a subrogation surety bond instead. Furthermore, if no assessment is available to validate charges, the case lacks the commercial basis needed for enforcement. 7. Establishing a de facto small claims forum. By applying the three questions method, one reframes the proceeding as an inquest or small claims forum. In such a setting, no attorneys may operate. Only first-hand witnesses may testify. All claims must be substantiated by sworn testimony. Failure to present a credible claim results in default, allowing the respondent to withdraw without prejudice. 8. Commercial foundations of legal proceedings. The legal system functions within a commercial framework, underpinned by double-entry bookkeeping. Indictments and citations function as securities, with commercial value assigned and accounted for within federal ledgers. The Treasury is central in this process, as any enforcement requires an authorizing order. 9. Sovereign representation and strawman theory. The individual, or principal, is seen as distinct from their legal persona, strawman. In court, representing oneself as attorney-in-fact for the strawman allows one to act in a public capacity while retaining sovereign status under international law. Engaging in co-business with the court through improper pleading risks defaulting to their jurisdiction. X. Concluding considerations on jurisdiction and immunity. Legal authorities operate under legislative jurisdiction and are required to possess formal delegation orders. Without evidence of a legitimate claim or order, the case lacks cause of action. Public officers require the appearance of jurisdiction, but such presumption must be rebutted by demand for specificity, namely, a bill of particulars. If no valid claim exists, a statement may be made, there being no further public business to carry on, I'm withdrawing. 11. Legal metaphors and the role of consciousness. Legal concepts often mirror metaphysical ones. Circuit courts symbolically reflect circuits of consciousness. A direct examination targets the conscious mind, a cross-examination probes the subconscious. Preserving internal coherence between the two maintains legal and physical immunity. 12. Public and private legal constructs. Two roles are recognized in statutory law, employer and employee, tied to one's tax identification. Preferred stockholders, principals, hold credit and debit power, while common stockholders, public citizens, serve as collateral. When someone pays a fine using public currency, no actual debt is discharged. The act constitutes a bribe or an acknowledgement of liability. By accepting charges for value and requesting the court's order, one seeks access to the commercial mechanism underlying judicial proceedings. 13. Final reflection: commerce as the foundation of law. Law is secondary to commerce. Without an underlying commercial agreement, legal action is unsustainable. The foundational inquiry remains: is there a valid claim supported by first-hand testimony and commercial documentation? If not, the court's authority collapses under the weight of its own procedural emptiness. The three questions approach, grounded in public international law and commercial equity, serves as a method of jurisdictional and procedural inquiry aimed at ensuring transparency, lawful authority, and the preservation of individual rights.